Good afternoon, and welcome to this special Brennan Center for Justice event. For those of you who are joining us for the first time, the Brennan Center is a nonpartisan policy institute that works to repair, revitalize, and to defend our systems of democracy so that our institutions work for everyone. My name is Kareem Creighton. I'm the Senior Director of Voting and Representation at the Brennan Center, and it's my delight to moderate this conversation this afternoon. Before we get started, let me run through a couple of housekeeping notes. First, an important note, the Brennan Center is nonpartisan as an organization, and while we cannot promote or oppose any candidate for office, what we can do, and what we're charged to do today, is to vigorously debate the policies and the positions that matter for our democratic system. Second, civility. It's a value we take seriously. And for that reason, those who post rude or intemperate language in our message streams, either on YouTube or Facebook, are going to be removed from the conversation. So, simple answer, just don't do it. Third, live closed captioning is going to be provided for this conversation. And last, we ask that you follow along with this conversation on social media using the hashtag Brennan Center Live, one word. Now, with that out of the way, on to today's program. So as you all know, we're at the end of June, which means that we, along with the rest of America, are sitting in anticipation of pronouncements from the Marble Palace on First Street in Washington, D.C., otherwise known as the Supreme Court. And under the helm of the conservative supermajority there, the past two Supreme Court terms have brought us rather dramatic rollbacks in issues like reproductive rights and affirmative action and environmental protection. This term obviously promises to be no less consequential, with rulings either issued or expected on issues like domestic abusers' gun rights, federal agency power, racial gerrymandering, and presidential immunity. The Supreme Court's hold on our country is about as strong as it has ever been, but it doesn't really inspire the same kind of reverence it once did. If you look at most polls, the approval rating is around 30 to 40%, which is quite historically low. Regressive rulings, combined with recent reports of justices receiving lavish gifts from conservative donors and flying flags of insurrection, have all eroded the public's trust in the institution as a whole. And there are obviously cries, understandable cries for reform that are coming from a lot of different quarters. In his book, The Supermajority, How the Supreme Court Divided America, Brennan Center President Michael Waldman examines the court's hard right shift, blockbuster rulings from its first terms, and the string of ethics scandals trailing the justices. We are delighted, of course, to have Michael here with us today to discuss the Supreme Court's latest high-profile rulings, which decisions we're still bracing for, and finally, solutions to balance our government. And there's Michael there. Good afternoon, Michael.
Good afternoon, Kareem. It's great to be with you, and I can promise to be civil, but I can't promise not to be intemperate. So,
well,
do my very best.
The floor is open for a lively discussion. Let's get to some questions, but I'll just note, of course, we're going to save time for the members of the audience who are listening to ask questions at the end. So you'll have a little pushback, which I hope will also be lively and vigorous as well, Michael. So let's get right to the questions. So in your book, Michael, you made a lot of accurate predictions in the first edition about what you would expect from the supermajority. What you didn't foresee, though, was this cascade of unprecedented ethics scandals. I'm going to let you decide whether or not you use the C word, and you can decide how and when to use it. But the question I want to just focus on is the most senior justice on the present court. How serious are the allegations against Clarence Thomas?
I think they're pretty serious, and the C word is corruption. And in some respects, when we think about ethics, that can have a bit of a tinny ring, oh, can I take that cup of coffee? Did I forget to fill out the form properly? What we have now learned, and indeed we learned it since I finished the first edition of the book, which was not very long ago, is that Justice Thomas has had his lifestyle subsidized for decades by a very wealthy conservative activist named Harlan Crow. And ProPublica, especially, as well as the New York Times, revealed quite a bit about this. Crow provided gifts, travel, many other things worth hundreds of thousands of dollars. Even more than that, it turned out that Harlan Crow, bought Clarence Thomas's mother's house and paid for renovations with her living in it. And he paid for Justice Thomas's surrogate son's education as well. And if we were looking at a state capital somewhere at Springfield, Illinois, or Albany, or something like that, and it was the local state senator and the local business guy, we would say, "Oh, we know what that is. That's corruption. These guys, the public official is on the dole from this wealthy individual." Unfortunately, that does seem to be the case here. This was not disclosed. Interestingly, it had been disclosed up until 2002. Then the Los Angeles Times wrote a story about it, so Justice Thomas decided the answer was not to disclose it anymore. And where it does, I think, connect up to the broader story of the court. At one level, Thomas is sort of literally off the charts. There was a recent study that showed that he received more in gifts than the rest of the justices put together. So in that sense, he's an outlier. But there's one way in which he's not an outlier, in which his story is the story of this court. In part, it's the story of the court because his views increasingly are the most influential. But it's also the case that when you look at that ProPublica story, the one that revealed a lot of this stuff, one of the things they had was a painting from a luxury hotel where Thomas and Harlan Crow would hang out. And it was a painting of Crow and Thomas. They're sort of smoking cigars in front of a lake, and honestly, to me, it looked like the painting of the dogs playing poker. But there was an interesting thing. There was Thomas, there was Crow smoking cigars, and the third prominent person in the painting is a man named Leonard Leo. He, of course, for many of our followers will know this, he is the de facto head of the Federalist Society. That is the organization that built this court, the very conservative legal organization that has done more than anything else to, first of all, he introduced Crow and Thomas to each other, but the Federalist Society went from being a student club to a very well established, very effective, very well oiled, and very well funded political machine. And in an institution with lifetime tenure and so much power, that's troubling.
There you are. Thank you for that. And it's interesting. As you were talking about the Federalists, even, the other instance where the Supreme Court had a question about ethics involving Abe Fortas. I'm sure you know that story. It sort of pales in comparison, of course. I'm interested actually in, of course, a colleague of Justice Fortas, the person who is lent his name to this institution, William Brennan. I want to talk a little bit about the court's evolution, ideologically speaking. When Justice Brennan was on the court, of course, in the midst of the Warren era, we saw a lot of development of cases that are key to, the agenda I deal with voting rights. But across the board, he really was considered in many ways the sort of liberal leader ideologically on the court. But he also, as you know, saw this shift on the court, partly started by Fortas. Of course, we're at a different stage, in part by the Leonard Leo story. I'm interested in how you characterize the rightward tilt at this stage. Is it something that you characterize, whether it's in quantity or in quality of these cases? What's different about the supermajority?
I think in some respects, we're seeing something like we've never seen in this country before, in the degree to which this court, with all this power and this minimal accountability, has been captured by a faction of a faction, by an organized political operation. But it's not the only time in the country's history when the court has engendered controversy and indeed backlash, and in some respects has overstepped. And I talk in my book about the fact that the Supreme Court, the part of the Constitution that deals with the federal courts is only 1/10 the length of the part of the Constitution dealing with the presidency and the Congress, the democratically accountable branches. The court has only attained the role it has in our system because we give it that power and because it has legitimacy, and in a lot of ways because it reflects, in some respects, the consensus of the country, for better or worse. There were a few times in the country's history, not that many, but a few times where the court has really, politically at least, overreached. The Dred Scott decision, which was so egregious that it led to the rise of the Republican Party in response and the election of Abraham Lincoln as president. The period at the beginning of the 20th century that the law professors and lawyers will call the Lochner era, after one particularly notorious case, which was when the very conservative justices of that time thought their job was to keep government from stepping into the economy to protect public safety and fair markets in the early fights. And I think that the Warren Court is something I'm somewhat critical of, and really the years after the Warren Court in the book. And that, surprised a bunch of people in reading the book, because of course, as you say, we both are privileged to work at the Brennan Center, which was started 3 decades ago by the family and clerks of Justice Brennan when he left the court. He was still alive for a few years at the beginning, and he was the great playmaker, as they called it, of the Warren Court. And the Warren Court was the one time, I think, in the country's history where the Supreme Court, in a sense, was ahead of, or at least riding along with, the country. It was not a reactionary force, but started out with such extraordinary important rulings like Brown versus Board of Education on racial segregation and other issues of that kind, but did so many of the things to build the society that we take for granted now, whether robust political speech, one person, one vote, Miranda warnings, which everybody's familiar with, and so many other things. But what happened was, I agree with the substance of these rulings almost invariably, but to have them one after another made by unelected judges, and especially in the years after Warren was there with cases like Roe v. Wade and other cases, these began to create their own backlash of people saying these liberal rulings are too political and that they're not legitimate. And what you wound up having happen was the rise of many years of organizing by conservatives in response to the liberal Supreme Court. And in a sense, we're living in that backlash today. I think we're in a moment of that nature where this court is moving with just as much energy and the backlash is growing very fast. The one difference, interestingly, with Warren and the Warren Court and with Justice Brennan, they did extraordinary things especially to extend the protection of the Bill of Rights to all Americans and to states. They imposed the Bill of Rights on the states, which people don't realize. It had not, generally speaking, the Bill of Rights had not been considered as applying to states up until the 1950s and 1960s. And that's where the bulk of criminal law happens. That's where the bulk of government happens. But Brennan and Warren and those justices were very careful about stepping on the toes of Congress. They understood that Congress and the president were supposed to be the preeminent federal body. And the Warren Court almost never struck down a law passed by Congress. Now, when you think about this court, when you think about the Roberts Court generally, gutting the Voting Rights Act, Citizens United, and all the other cases, this court has grabbed a lot of power from Congress that Justice Brennan would be rather shocked by.
So let me be controversial for the moment. Would you say then, for Leonard Leo and others, is this their version of their Warren era, remaking America in their image?
I mean, I think they would say so. They, both ideological camps trade their clothes quite a bit. You now hear liberals say more than they used to, oh, we need judicial restraint. And at the same time, you see the conservatives on this court say things like, well, this case that Roe v. Wade is just as bad as Lochner or Plessy v. Ferguson. Those examples in their view of judicial overreach. They see this as their Warren era. They see this as their political era. I think that it's very hard, even as critical as I am of many of the rulings by the liberals in the 60s and 70s for overreach, not for the substance, but for the kind of way they went about it. What this court is doing now, in some respects, is much more breathtaking. In the very first year of this 6-3 supermajority, in 3 days, the last 3 days of that term in 2022, the first day was the Bruen case, which was by far the most extreme Second Amendment case in American history, saying, in effect, that you cannot consider contemporary public safety concerns when looking at a gun regulation, only quote history and tradition, i.e., did they have this gun law back in the 1700s? The next day was Dobbs, with its impact on society and putting at risk all these other privacy rights that people are relying on. And the third day marked the beginning of a very significant assault, which continues into this term and the future, an assault by this Supreme Court on the ability of government to protect public health and safety and the environment through its regulatory activities. That was a case back then called West Virginia versus EPA, where the court said that even if Congress had passed a law, in that case it was about a climate change regulation, and the Clean Air Act as passed by Congress, even if Congress passed a law that actually gave the EPA the ability to do this regulation about climate change, the topic was just too important. They coined something that they made up called the major questions doctrine. And basically what they said is if something's really big deal, then the agencies can't do it. And the courts get to decide what's that kind of major question. So that's the beginning of the next phase of this supermajority. And that's going to have an impact, I would suggest, deeper than many, many, many of the other rulings that are a little more vivid and a little more publicly controversial right now.
Great. Let's talk a little bit about some of the cases that have emerged since the first edition of your book. We've seen the court say things about the Voting Rights Act, the independent state legislature theory, and about affirmative action. It's kind of surprising to your earlier point about how swiftly they've moved on big questions. I'm interested in your take on which of those cases since your first edition stand out, and what do they tell you about sort of the overall picture that's emerging on how this supermajority wants to reshape America?
So in the first term of the supermajority, they were hurtling forward at a really rapid speed. And pass in effect like a legislature. You know, when you think about the first three big rulings, abortion rights, gun rights, climate change, that doesn't sound like a court. That sounds like a political caucus. The second term last year, and the paperback really goes into this, had some twists and turns. Some of this was John Roberts, the Chief Justice, doing his best to regain control of the situation, because he is both an institutionalist, and wants to take things in the same direction as the other conservatives, but has his hand on the steering wheel and on the brakes. And so in those three cases that you mentioned, one of them was a genuine positive surprise, the Milligan case, which, as you, of course, Kareem, know because you work on this and are such an expert on this. The Supreme Court in 2013 gutted Section 5 of the Voting Rights Act, which was the most effective part of that landmark civil rights law. But there was still a part of it, a shard of it that was left, Section 2, which gives you the right to sue after the fact for discriminatory voting practices. And they, rather than weakening that, they upheld that and used it to say that the state of Alabama actually needed to create another congressional district likely to elect a Black member of Congress. And so that was a genuine surprise and a pleasant surprise. The second case you mentioned, the independent state legislature theory, even in my edition of the book, I in the end, as it turned out, was not surprised by the ruling, but they should not have heard the case in the first place. This was the idea that the Constitution somehow had given state legislatures the power to set federal election rules with no checks and balances from state constitutions, state courts, governors, voters. The Constitution had given the legislatures that power, and that nobody ever noticed it until now. It was a crazy crackpot idea, but somehow the court thought it worth hearing and taking. There was such an overwhelming outpouring of opposition to this notion, and the Brennan Center, I'm proud to say, had a lot to do with that. We coordinated amicus briefs and did scholarship. That in the end, that was a 6-3 ruling, resoundingly rejecting that idea. The third big case that you mentioned was the affirmative action case, and this again has had a very significant impact on opportunity and admissions for people applying to higher education. And it's not just college admissions, because, you know, the one of the things about affirmative action, at least in this case, was, there was a case involving Harvard and one involving the University of North Carolina. These are pretty elite schools. But the way they wrote it and the way the rhetoric and the rationale has played out, it is being used by the same people who challenged the Voting Rights Act, the same people who challenged affirmative action in higher education. They are now going after DEI programs in corporations. They're saying that companies or other institutions can't have a program to try to help young women of color get loans or any of these kinds of things that are part of the many, many different facets of how our society aims to seek equality and to get the best out of our diversity. And as with so many Supreme Court rulings, it's the rhetorical ramifications of a ruling like that live on and that are going to affect the lives of millions of people.
Indeed. I want to turn to the court's current term. As I mentioned earlier, we're all waiting day by day to see what the court issues in terms of its opinions and, of course, its reasoning. As you said, there are a lot of wild and new theories that the court is introducing us to. We're waiting, by my count, on about 19 decisions more before the end of the month or whenever the court decides to wrap up its business. I'm interested, based on what you know and maybe what's coming, what do you think this term is going to be known for in terms of the court's output, either in its holding or it's in its reasoning or theory?
Well, as you know, Kareem, from your years as a law professor, it's very unusual that they take so few cases. It's also very unusual that they're waiting as long as they are. Maybe we'll find out they're gouging each other's eyes out and pulling their hair or something, but I think there's probably a lot of politics behind the scenes. When we ask, what is this term going to be known for? I think over the long run, more of these cases cutting back on environmental protection and the regulatory capacities of government. I think there are going to be some important rulings where they may trim and pull back on some of the more extreme implications of their rulings on the Second Amendment. But if you ask me, and you've heard me rant and rave about this a lot, I think that the most significant thing this court will have done this term, they already did. And that comes in the Trump immunity case. The question is whether an ex-president is immune from criminal prosecution just because they were once president. And it's a legally easy case. The answer is no, they're not immune. And everybody has known for decades and decades and decades, the assumption has been that current presidents shouldn't be prosecuted, but former presidents most certainly could be. The case, of course, involves the federal prosecution for Donald Trump's effort to overthrow the Constitution's peaceful transfer of power. It would be, in a sense, the trial of the century. It would be arguably the most important criminal trial the country's faced. And it's a legally easy question. The special prosecutor, Jack Smith, asked the Supreme Court to make it clear, to clear it up last year. And instead of acting quickly, as they should have, the court dragged its feet and dawdled and found twists and turns and procedural reasons to slow it down. And so that in the end, they heard the argument in the last hour of the last day of arguments for the term, and they still haven't issued the ruling. And in the argument, they said, this is so important. There's so many interesting issues here. Justice Gorsuch said, he intoned, we must rule for the ages. And I wouldn't be surprised when the ruling comes out, maybe tomorrow, who knows? I wouldn't be surprised if they say, of course, Trump can be prosecuted for at least some of this. They may slow things down by sending it down to the trial court for more parsing and slicing. I wouldn't be surprised if we hear all kinds of rhetoric, sonorous rhetoric about, nobody's above the law and presidents are not kings. And that's all very nice. But they've already given Trump the thing he craved, which is time. Their timetable meant that voters will not know, that the trial will not happen before the election. Voters will not know the information in the trial, and they won't know if he's convicted. We hear people say, stop the steal. This to me is start the stall. And basically, nothing the court does or says this term is going to have as significant an impact on American democracy, in my view, as what they've done already with the stall.
So, Michael, let me play devil's advocate for a moment. I'll put the law professor hat on and just take you back to 2020. Now, the people did
on me. That's all.
Oh, not at all. Well, you're the only one in the audience today so far, so you get all the questions. So let's take it back to 2020, right? The person defending the supermajority would say, well, wait a minute. That was the moment for the court to swoop in, a la Bush versus Gore, deliver at least, some question about the transfer of power to Donald Trump. They didn't do that, right? There were a lot of these cases. They got to the court. The court didn't take the opportunity to jump in then. But okay, maybe that's some evidence that the court doesn't jump at every political opportunity. Do you buy that argument, or what's different now?
Well, it's a good question, and you're absolutely right. As folks know, in 2020, there were 63 court rulings where judges at various levels rejected Trump's claims of a stolen election. The Supreme Court stayed very far away. They didn't hear any of the cases. They rejected, more than that, they rejected the case, for example, brought by Texas against the state of Pennsylvania, saying that Texas didn't think Pennsylvania had implemented its own election laws to Texas's liking. And the court stayed out of things. And in fact, throughout Trump's first term, it was a conservative court, certainly. It was a Federalist Society court. You could argue in many ways it was a Republican court, but it was not really a MAGA court. They were not particularly interested in bailing Trump out of his legal troubles on this and on a bunch of other cases. What's different now? It's a troubling question and maybe some troubling answers. One of the answers is, and I hesitate to say this, Trump's poll numbers are a lot better than they were in 2020. And therefore, they seem more willing to kind of be seen as helping him out and doing his bidding. I'm not saying that the case earlier in the term that folks will remember, where Colorado had thrown him off the ballot under the 14th Amendment, Section 3 of the 14th Amendment, for engaging in insurrection. And the Supreme Court said, no, one state cannot do that. I didn't think that was wrong. But this case, they could have disposed of really easily and really quickly. It also suggests in a worrisome way that what we saw in 2020 might have just been Amy Coney Barrett and other members of the supermajority kind of getting their sea legs, and now they've got some more self-confidence. I would say as well that so much of what Trump did back then was improvisational, slapdash. The arguments about the election, were nutty. They were Rudy Giuliani in the press conference with the hair dye dripping down his face and claims of voting machines flipping votes and ballots that supposedly had bamboo fibers in them and that proved they came from China, and on and on. Now, Trump is, generally speaking, surrounded by far more competent and professional, if extreme, people. He's laying out his case of what he's going to do if he wins another term in a audacious, but again, more organized and professional way. And I understand that the issue of whether a president is immune from prosecution is a real issue. It has never been ruled on by the Supreme Court because no president has ever been indicted before. But it just was it's not that it wasn't an issue. It was just an easy issue that they could have disposed of quickly. So, but I think we're going to be, as we look forward to the possibility of a second Trump term, one of the questions is this Supreme Court going to stand up to him if he tries to abuse power? This is not a good omen.
So I asked you earlier about one member of the court and the question about ethics, and I wish I could only have one case to share with you. But of course, there's a second member that we're all looking at who has apparently a penchant towards Wexicology and playing around with flags, and that's Justice Alito. It was not obviously something I think any of us could have anticipated early on, and certainly not when you wrote the book. I'm interested.
The bingo card did not have this particular scandal on it.
Not even. I think you could go to Vegas and get pretty good odds that nobody gets that. But the question about Alito, whether or not it was him or his wife and where the flags were, I'm interested in your thoughts on how this story about Alito, these stories about Alito, tell you something about his role on the court, and really how the court seems to be operating within our democratic system, particularly on cases like presidential immunity, which you just talked about.
It's great. Thomas, as I said, is in a lot of ways the intellectual leader of the direction of the court, because his version of originalism, which was for a long time considered a very fringe position, really has become dominant in a number of the key cases that they're doing. Alito is not as much of an intellectual leader. He is more partisan, however. Studies have shown that he is the most predictably partisan of all the Supreme Court justices. And of course, he was the author of the Dobbs case. In this instance, just to recap some of the still rather astonishing details, it turns out that I'm not going to grant the fiction, the fig leaf, that he didn't have anything to do with this. The Alitos flew an upside down flag just days after the January 6th insurrection, after people charged into the Capitol building, killing police officers and causing massive damage, flying upside down flags. They flew the flag of insurrection over their home. And then there was this whole story about it was a fight with neighbors, which the New York Times, which broke this story, then showed really was not true, that the timeline didn't work. But then it turns out that Alito flew a different flag at his vacation home. And this was not the flag of insurrection. In a way, it was less troubling, but it was a flag that is being used by sort of Christian nationalists as a kind of a marker of a very, very intensely right-wing theological approach to politics. And the combination of these things, and one of the things, again, it is mind-blowing that a Supreme Court justice would be entangled in partisan advocacy and political advocacy in this way. First of all, I made a little sign that I hung on the wall of the office here of great quotes from famous Supreme Court justices, Oliver Wendell Holmes and William O. Douglas, and under Alito it said, "My wife is fond of flying flags." That was his defense, which is kind of what's amazing about that. In part is clearly they worked on that. That was workshop. It's got alliteration. This is great. So they thought that was a good answer. It's not so much the partisanship. Nobody's surprised that he's conservative, but that he basically was willing to publicly take sides in the very issues that were in front of the court around the Constitution. This was at the time the court was considering a number of cases around the insurrection. And of course, I mentioned two of them this term. There's actually a third one as well, where whether the Colorado case or the Trump immunity case or another case called Fisher about the laws that are used to prosecute the people carrying those upside down flags, that Alito is perfectly happy to participate in them and not to recuse himself, not to step back. Similarly, Thomas, whose wife was involved in some of these activities, also participated without stepping back. Recusal is one of the core functions of judicial ethics. And one of the things that has been so noteworthy about the Supreme Court in this moment is that until quite recently, it was the only court in the United States with no code of ethics. They announced one a few months ago. They said this is just to clear up, quote, the misconception that somehow they have a problem by the public. But it's got a very toothless code of ethics. A real code of ethics would say that these judges need to step back and recuse themselves from these cases.
Yeah, there's no gambling in Casablanca, apparently.
Yeah.
I want to ask you about the current president's reaction to these scandals. Obviously, he's a leader of another branch of government. He's been rather muted, that is President Biden, about both of the Thomas and Alito scandals. What do you think this tells us about, his role in this? What do you think is holding him back from saying more?
This is something I've written about and we mull over all the time because, yes, the president is the head of another branch of government. These are equal branches and they each have their realm, but it's entirely legitimate for presidents or candidates for president to talk about the Supreme Court, to talk about its rulings, to talk about it as an institution, not just, oh, I like this ruling, I don't like that ruling. But I think the Supreme Court has gone off the rails, that it's missed its mark, that that in many ways it's showing corruption or ideological capture. President Biden has been very reluctant, to the frustration of a lot of Democrats, to take on the Supreme Court as an institution. He is an institutionalist himself. He's been in government for half a century or more. He was the chair of the Senate Judiciary Committee and actually had a lot more to do with the current, for better or worse, the current era of Supreme Court confirmations than just about anybody else. But he was very reluctant. And you mentioned that I was a member of a commission that he appointed, the Presidential Commission on the Supreme Court, designed to look at Supreme Court reforms. The commission was instructed at the outset not to reach conclusions, and we didn't. But not just that, the report was done, and for a year they wouldn't even acknowledge that they'd received the report. Finally, they had a little event with us at the White House, which was very nice. But he was not interested in engaging in this way. I would say some things have begun to change. First of all, the political power of the backlash against the Dobbs ruling in particular on abortion rights and reproductive freedom is obviously something President Biden and his party are paying attention to. And if you think about during the State of the Union address, he was pretty direct in saying to the justices of the Supreme Court who were sitting there, you're going to feel the political blowback from this. I think that this current stuff with the flags flying upside down and the scandals involving Alito and Thomas also makes the issue pretty intense. And it does seem to be the case that about a week ago, President Biden finally unloaded on the Supreme Court. He said they're out of step. There hasn't been a court like this. And he said that whoever is president, he predicted would get 2 appointments to the court. And he said mine won't be flying the flags upside down. Now, that was noteworthy on the one hand. On the other hand, he said at a fundraiser, I don't even think there were cameras there. So I hope that the issue of the Supreme Court and its conduct and the philosophical approach it's taking and its role, I hope that that becomes a big public and political issue. I hope there's a push for reform as part of that. I think it's entirely legitimate to yell at the Supreme Court as part of politics. It's what's gone on throughout American history. It may be very possibly that Joe Biden is not the person to do it. But I think the next generation, the next wave of Democrats are not going to have those hesitations.
So I have one last question, but before that, I want to remind our audience that we are going to then move to question and answer. So if you have one burning that you want to share, make sure you post it. But the last question really gets to the yelling part. That is, who does the yelling? I suspect you, like I, have heard from a lot of people about the Supreme Court, and it ranges in tone from being frustrated to feeling like powerless. And people are casting about trying to think through what can be done to fix some of these challenges that we've talked about. Let me just tee it up for you. Is there a way out of this? Is there a reform answer to this that helps us get to a better place with this court?
I think there are a lot of ways for people who are unhappy with the court or its direction to push back. Some of it has to do just with the politics, with making sure that who are the nominees going to be becomes, for example, going to be an issue in the campaign. There's also things Congress can do if the Supreme Court makes a ruling rather, that very often Congress can undo the ruling if it just does its job and passes legislation. So in the past couple of weeks, the Supreme Court made a ruling on guns, saying that the regulation that the Trump administration put out, which was actually backed by the NRA, saying that you could not modify a semi-automatic weapon with a bump stock to turn it into a machine gun, basically, that overstepped. But that wasn't a ruling on the Second Amendment. It was a pro-gun ruling, but it was based on what I would say is their misreading of the language of the law that Congress passed. So look, Congress could step up and pass a law making clear what it meant. But I do think that it's not just responses to the Supreme Court, constitutional amendments, all these other kinds of things that we could be doing. But I think the Supreme Court itself, reform of the Supreme Court itself, has to become a central public issue in American political life. Now, we've talked about the ethics. Congress can and should pass strong ethics laws for the Supreme Court. Nobody is so wise that they should be the judge in their own case, in my view. Congress has that power. Actually, Justice Alito made an interview where he said, no, Congress doesn't have the power. And Justice Elena Kagan gave another interview saying, oh, that's nonsense. Of course they do. The answer is, of course they do. But I think the most important reform right now that we at the Brennan Center are fighting for and pushing for is to establish an 18-year term limit for justices on the Supreme Court. Nobody should have too much public power for too long. And in a sense, this is a kind of an insight that George Washington taught us when he stepped down after 2 terms as president. The interesting thing about term limits, Kareem, is they're very popular. They're very popular with Republicans and with independents, as well as with Democrats. It's how it's done in every state Supreme Court, except for one. It's how it's done in the constitutional courts of other countries. They all have a term limit or an age limit or something like that. As I say, it's very popular, and we think it certainly can be done by constitutional amendment, but we believe it can be done by statute as well. And especially if coupled with something giving the presidents an appointment every 2 years so that you kind of take some of the toxicity out of the confirmation process and make it a more normal occurrence. All those things taken together really would bring some accountability to the court and bring the court more in line with the country that they are seeking to have such an impact on. I think it's an idea whose time has come and will happen sooner or later.
All right. Well, thank you for that, Michael. I agree with you about bringing the United States more in line with the rest of the democratic world also, all of which keep terms for members of their constitutional courts. Let's now turn to questions from our audience. Thank you for indulging mine. I'm going to turn first to a question that I've been thinking a lot about. It comes, let's see, here's the question. How have the lower courts dealt with the Supreme Court's new decision-making criteria, like, as you mentioned, the major questions doctrine and the history and tradition test? Feel free to talk about the Fifth Circuit if you want.
Yes, well, the Fifth Circuit is the rootin' tootin' Texas appeals court that keeps making rulings that are so extreme that even this Supreme Court seems willing to stop them and strike it down. But more broadly, the question implies rightly that we have a lot of focus on these 9 individuals, but the whole federal court system is a lot of people with a lot of power and cases that never get up to the Supreme Court, which have a big impact on people's lives. When the Supreme Court says that only history and tradition, for example, originalism as they would see it, is how we should look at the Second Amendment, you wind up with cases like in upstate New York, a judge looked at the law that New York State had passed and said, well, history and tradition, for it to be a tradition, two examples of laws from the colonial era, that's a mere trend. For it to be a tradition, you need 3. And this judge could find no example of 3 laws from the colonial era banning guns from sleepaway summer camps, let alone subways, which of course wouldn't be invented for another 100 years. In other words, what the court does rings loudly throughout the rest of the federal courts. And what you also see too is that a lot of the lower court judges are very extreme. We all know Judge Cannon and how she is handling the Trump documents case. We're familiar with Judge Kaczmarek, who was the Texas trial court judge who tried to ban mifepristone, the abortion medication used in most of the abortion care in the United States. This one judge tried to ban it. You see this stuff empowering some of these very extreme people. Now, I have a question for you on this. You're following in such detail how the rulings on the Voting Rights Act and racial discrimination are playing out in lower courts. And again, we're seeing it right in ways that don't make the front pages. They don't get up to the Supreme Court, but they have a big impact.
Yeah, I tend to agree. I didn't know I was on the hot seat too, but I would 100% agree with the way in which both the court is introducing new and sometimes scary theories about the way the Constitution operates. But in response, as I suggested earlier, and you reacted to, the Fifth Circuit, and there are judges around the country, not just at the circuit court level, but the district court level, that are sort of introducing these ideas as well. And they range from reinterpreting Reconstruction Amendment theories and statutes that have been applied to essentially secure the freedoms of freed persons that are now being used, as we suggested earlier, to cut out opportunity for getting rid of inequity for people of color, to cutting back on opportunity to elect candidates in our redistricting cases. It's quite scary stuff. And it raises hard questions about what, frankly, lawyers are to do in trying to offer arguments in support of their clients, but also, frankly, how legislators do their business. But it's not about me. I'm going to get back to the audience questions. You mentioned gun rights. I wanted to talk about another question that came up. In its upcoming ruling, U.S. versus Rahimi, do you think, Michael, that it's likely that the court will try to walk back its expansive, was the question, Second Amendment decision in Bruen?
I think they will a bit, probably. There's no other explanation for why they would have taken the case if they were just going to rubber stamp what the Fifth Circuit did. But that case is a good example of the extreme lengths to which the logic of the Bruen case would take the country. So again, what Bruen said, remember that the Supreme Court only ever said that the Second Amendment protects and recognizes an individual right to gun ownership for self-protection since 2008. That was the first time. That was the Heller case. It was really recent, but the Heller case also said, yeah, but you can still have gun regulations and gun laws. And the Heller case was written by Justice Scalia. And they asked Scalia, what's the difference between you and Justice Thomas? And Scalia said, well, I am an originalist, but I am not a nut. Well, Thomas wrote Bruen, and Thomas, as a matter of pride, does not look at the 200 plus years since the founding era. He doesn't look at the consequences. And his approach to originalism is not to say what are the ideas behind these rules, what were the founders even thinking, but did they have a law like this back then? The Rahimi case shows how damaging that can be. In that case, Mr. Rahimi was somebody with an adjudicated record of domestic violence and thus couldn't have a gun. And the ruling is, well, back then, that wasn't a problem. That was not seen as criminal. Social values back then thought that was not such a problem. So therefore, we can't have that rule now. It's such an outrageous implication that I can't see why the court would have taken the case except to say, no, you can take away Rahimi's gun. Now, how will they do it? Will they basically say, if your name is Rahimi and you live in Texas and you have an adjudicated record of domestic violence, you can't have a gun? Or will they say something broader, as I hope they will? Will they say something that says, of course you can take public safety and contemporary issues into effect, or if things were not thought of back then, we have to interpret it ourselves. Kavanaugh and Roberts in the Bruen case, they voted for the majority opinion, but they also did a concurrence, which is a separate opinion saying that they went along with the result but had a different reasoning. And in the concurrence, they said that the problem with the law that case Bruen struck down was not that it didn't follow history and tradition, but that it wasn't a well-constructed law, that it was not rational. If that's really the approach, then that forges a new and different majority on gun issues with the liberals who had dissented. But as we saw with the bump stock case, the NRA is fading as an institution. It is bankrupt. Its leaders are accusing each other nonstop of corruption and chicanery. The social ranks of gun owners is shrinking. Many fewer people own guns in the United States than they used to, even though there are more guns. But the one place it lives on is in the doctrines of the Supreme Court, because that's where the lifetime appointment comes in. And all these justices, this supermajority, were all put in office with the heavy backing of the NRA.
All right. Well, next we have a question more broadly about government regulation. Can you elaborate on the court's attack on government regulation? Where did we see that come up this term, and what are the consequences of it?
Yeah, like I said, I think this is a really big long-term thing. In a lot of ways, it's less vivid, less, emotionally gripping than abortion or guns or affirmative action, but the consequences are very significant. In 1937, uh, the long effort by the Alitos of that era, by the Supreme Court of that day, to curb government's ability to act to protect public safety and to act in the economy. FDR, President Roosevelt, had his big showdown with the court. One of the things that happened was the court backed down and said, we're no longer going to try to use the Constitution to stop government from acting in this way. In 1937, now that was how we built a modern country. But for a handful, really, of libertarians and right-wing judicial activists, that was a great tragedy. It was a terrible, terrible mistake. They call it the Constitution in exile. They wanted to bring back the Constitution in exile. There was an article in the New York Times Magazine 20 years ago saying, here's one judge who really believes in this notion of the Constitution in exile, who wants to use the court to curb the power of government to act. And that was an unknown judge named John Roberts. Well, Roberts has his moment now. And so starting with this case, West Virginia versus EPA, which said, courts can say that agencies cannot act if the question is a, quote, major question. You're seeing this chipping away of the ability of agencies to act. The big case this year will address something called Chevron deference. And don't go to sleep, everybody. It's not as arcane as it sounds. This was a practice that judges had of deferring to the experts in regulatory agencies when a law passed by Congress was vague or ambiguous, and the experts really needed to be able to make some decisions about what was needed, and the courts would defer to that. It is highly likely that this court is going to overturn rather, Chevron deference, and combined with this major questions thing, it really is going to change how we protect the environment and worker safety and all these other things. There's a few other cases where the court, they're not just rubber stamping everything. They are always very solicitous of Congress's ability to decide how to pay for government. They rejected the idea that some right-wing lawyers and attorneys general had. They rejected the idea that, for example, that walling off the Consumer Financial Protection Bureau from the ups and downs of politics and having its funding steady by the Federal Reserve, that somehow that violated the Constitution. Earlier today, they went along with a tax law that tried to raise taxes on money coming in from overseas. So the taxing power, which is in the Constitution, still seems to be something that they are okay with. But bit by bit, they're taking on the core regulatory powers, and they're going to wind up using the Constitution to say that government can't be too active in protecting the environment and protecting public safety or fair markets. And that's going to really, really have a big long-term impact on many people.
Yeah, the administrative state is definitely on the block one way or the other. I want to pull back a bit with this question. If the Supreme Court's power depends entirely on its legitimacy, what happens if people continue to lose faith in the justices as neutral arbiters?
Right now, the Supreme Court's approval and trust in every public opinion poll has collapsed to the lowest level ever recorded. And that's troubling. And it's also troubling for the Supreme Court in its political project, because people are only listening to it because they still have this idea that it's a court and that its decisions are in some respects beyond politics. I wouldn't say above politics, but they're not purely politics. We're in uncharted waters if the court loses this legitimacy but plunges ahead anyway. Back in the Warren era, the court had an enormous amount of legitimacy. it got that legitimacy, among other things, with rulings like Brown v. Board of Education, where people got the idea that this was something that needed to be done. It was actually outside the white South. It was actually a very popular ruling. And the Supreme Court had a real glow out of that. And you think about the Kennedy assassination, when Lyndon Johnson was worried that there were all these conspiracy theories swirling around after the Kennedy assassination. Was it the Soviet Union that did this, the CIA, Castro? He said, I need the most trusted person in the country to head the commission to look into this. And he chose Earl Warren, who was the Chief Justice of the United States and a Republican, by the way. So that was a time when the court, even as it was doing what it was doing, had a great deal of residual public trust. And this court is making these wild and crazy rulings when people, a large part of the country, already see them as a bunch of political actors. And so, like I say, we're in uncharted territory. And I think the political backlash at the ballot box and in reforms like term limits are going to be part of the politics of our country going forward.
We are nearing the end of our time together. I want to pose one last question to you, Michael. And if you can, in a very few sentences, share with us, what do you think is the one thing that you want this audience, who is very, patiently listen to us talk, what's the one thing you want them to walk away with this afternoon?
I guess high blood pressure is not the right answer, though
No.
that is an appropriate answer. The Supreme Court justices are not wizards, even though they wear robes. They are not religious figures. They're government officials with lifetime jobs who are not elected. They have enormous power over all of our lives, and it's entirely appropriate for us to push back, to question that power, to demand that they not overstep their bounds, and to insist on reforms like term limits and an ethics code. What everyone should walk away with is this: the issue of the Supreme Court is an issue for our time and going forward. And if we're loud enough about it, if we organize about it, if we mobilize about it, if we vote about it, we can have a big impact on how this body acts and how the Constitution is read in our country.
Michael, I want to let you know I've scored you an A for participation in this session. Really, thank you for sharing your ideas and the book.
Did the reading.
Yes, and the writing too. So thanks for that as well. Let me also thank our audience so much for all of your helpful questions. I truly do wish we could have gotten to them all. I hope we got some ones that helped everybody understand a little bit more about where we are with this court and its upcoming decisions. Let me say, of course, we are looking forward to you all at the Brennan Center joining us for future events. In order to be the first to know when we are going to announce events, be sure to sign up for our events newsletter at, let me read it correctly, brennancenter.org/events. That's brennancenter.org/events. Finally, my name is Kareem Creighton, Senior Director, again, for Voting and Representation at the Brennan Center. I want to thank each of you again for your time and look forward to seeing you all in the future. Have a good afternoon.